This article deals about the need for restructuring the Supreme Court. There is a lot of subjectivity involved in deciding the constitutional benches or non-constitutional benches that deal with various cases. The cases might be constitutional or non-constitutional. Constitutional cases, as the name itself refers to, deals with the cases that require to examine the provisions of the Constitution, or cases that requires whether these are following the provisions of the Constitution. And this is an important task. Why? Because this country needs to be run as per the provisions of the Constitution. Non-constitutional cases deal with ordinary legal matters. Of course, some are of national importance, some aren't of national importance. In this article, we will see why there is a need for revamping the structure of the Supreme Court so as to deliver justice effectively and also improve the ability to see that the constitutional cases are dealt effectively. Why? Because presently we are not dealing with the constitutional cases as they should have been. The title of the article is "It's Time to Revamp the Structure of the Supreme Court. Relevance, Judicial Reforms, Structural Changes in the Judiciary." And Main's perspective, it is important to deal with the judiciary. The previous year questions: desirability of greater representation of women in higher judiciary, or tribunals, which refers to tribunalization of judiciary. Next, Supreme Court judgment on National Judicial Appointment Commission Act 2014, etc. Many such important cases or importance with regards to the Supreme Court or judiciary are important. Why? Because they have been asked repeatedly in UPSC Mains examination. The context is the CJI Chandrachud has announced his intent to create constitutional benches of varied strength as a permanent feature. That he wants to create a constitutional benches, and the constitutional bench which has varied strengths ranging from 5 to 7 to 9 to the max, and deal with the constitutional matters. And this is a permanent feature. Why he is trying to incorporate such changes is to improve our dealings with the constitutional issues. And what are the constitutional benches? These are specialized panels that deal with the constitutional matters that involve substantial question of the law and matters of constitutional importance. That is how they are defined. Formation of constitutional benches. Chief Justice of India is a master of roster in formation of the constitutional benches. That is, he decides the various judges who are to preside over these cases. So that leads to higher discretion power with the Chief Justice of India in deciding the judges who are supposed to preside over the proceedings of particular case on the basis of particular case. And thus what happens is, depending upon the inclination of judges, we could also predict the outcome of the judgment. That shouldn't be the case. But that is what one of the issue that present Supreme Court is facing. That why should Chief Justice of India be the master of roster? And the minimum, as we already seen, is 5 to maximum larger bench 9, and it is covered under Article 145(3). And the judges are generally selected on a particular basis. The basis has expertise, seniority, and relevance to particular constitutional matter. Though these are the parameters that we generally include or take into account while deciding the composition of the particular bench, yet the discretion with the Chief Justice of India is far higher. And the thing is that there is a registry under the CJ's instructions which assigns the cases to these constitutional benches. Now, why is the issue with this particular Supreme Court structure? The mixed case load. The thing is that the Supreme Court deals with not only the constitutional cases but non-constitutional cases. Together, they become such an overload as a task to the Supreme Court that its ability to complete the proceedings and decide on the case outcomes becomes a complex issue. And constitutional matters are of importance to this country, not only to the citizens but also how the government functions. But yet they are taking a lot of time. And Supreme Court has the paucity of time in deciding the constitutional cases because it has to deal with the overload of cases. And that is why Presently, 79,813 cases are pending in the Supreme Court. Next is the number of cases within these cases, that is, number of constitutional cases within these cases are lower. If you look at the number, in the year 2022, only 4 of the 1,263 decisions deal with the constitutional bench. That is, it is a fraction of cases. Despite having the urgency or need to deal with the constitutional cases, we are unable to do it. The other issues are discretion in bench formation with the Chief Justice of India, which we have already seen, and subjectivity in case assignment. That is, somehow we could also decide the outcome on the basis of the composition of the bench, and the composition is decided by the Chief Justice of India. Even if Chief Justice of India doesn't, or in the future if he doesn't decide the composition of these benches, if he's not a master of roster, you have to see that there is a particular criteria through which we could assign a case to the benches, and then see that it is not subjective. It is dependent upon various parameters that are objective in nature on the basis of the merits. What are the recommendations for structural changes? The reason for the recommendation of the structural changes that we are referring to is to see that the constitutional cases happen as frequently as possible as per the requirement of the country. So, there are certain recommendations given by law commissions as well as case laws of the Supreme Court. One such recommendation is given by 10th Law Commission, which stated that Supreme Court should be split into 2 divisions. One, the constitutional division, and the other is legal division. As the name itself suggests, one deals with the constitutional matter, the other non-constitutional matters. Like for example, Supreme Court also has the task as highest court of appeal. So whatever the decisions that are taken by the High Court could be appealed to the Supreme Court. That depends upon certain conditions that are enshrined in the Constitution. Those appeals should be heard by the Supreme Court, that because the Constitution envisions it, or Constitution directs the Supreme Court to do it. So that task is also be undertaken. But presently, as we have seen in the past slide, the constitutional issues dealt with the Supreme Court are far lower, which have to be increased, and one of the ways through which we could do it is this recommendation. Then, in the case Bihar Legal Support Society versus Chief Justice of India 1986, Supreme Court has said that it is desirable to establish National Court of Appeal. As we have seen, the cases that are appealed in the Supreme Court are far higher, and these take the time of the Supreme Court mostly. That is, Supreme Court mostly utilizes its time in dealing with the cases that are appealed from the High Court. So, this judgment shows the intent to create National Court of Appeal to reduce the caseload, because to reduce the time that Supreme Court takes in completing the proceedings or adjudication of the non-constitutional cases. And the 229th Law Commission Report 2009 has recommended to establish 4 regional benches in Delhi, Chennai or Hyderabad, Kolkata and Mumbai. So these regional benches deal with the matters same like Supreme Court. And why there is a need for creating these divisional benches is to see that the justice is accessible to different regions of the country. What pattern that we are witnessing in this country is, most of the appeals that happen to the Supreme Court are from the regions which are closer to the Supreme Court. The states like Punjab, Haryana, etc. These are the regions in which the High Court judgments are appealed in the Supreme Court in a greater manner when compared to others. Thus, we are denying the access of justice to different regions like South, West, etc. And if we apply these regional benches, we'll reduce distance being one of the criteria to avail justice in this country. And we could also see that the appeal, that is appellate jurisdiction, which is with the Supreme Court, because it is the highest court of appeal, it could do the task more efficiently at the same time in a greater magnitude when compared to having one Supreme Court at the center. And it will also set to constitute constitutional bench in the New Delhi to take care of the constitutional cases. So in this way, Supreme Court could deal with both the constitutional cases as well as non-constitutional cases. Merits of structural changes in the Supreme Court. Firstly, specialized attention could be given because special attention can be given to critical constitutional cases, because these structural changes will enable Supreme Court to deal with the constitutional cases in greater magnitude than was the case earlier. And specialization and expertise. We could have specialized benches which have the expertise to deal with various constitutional matters. As we have seen, allocation of the cases to the benches, which is composed of judges, is to be selected on the basis of the merit, and depending upon the constitutionality of the case, we could assign the case to the benches, and thus we could use the expertise to deal with these cases. Next is efficiency in adjudication. Now, because we have expertise and allocation is on the objective grounds, then obviously what we could expect is efficiency in dealing with these cases. Thus, adjudication of the matter will be done in a better manner. Next, coherence in judgment, that is consistency, rather than relying upon the inclination of the judges. Here we are not suggesting that the quality of the judges differentiate from one another. The way they come to the conclusion varies from one judge to the another. There is an element of subjectivity in deciding a particular case that ultimately depends upon how a particular judge interprets the law or interprets various values that he or she takes into account while evaluating a particular case. But ultimately, what we are dealing with is the quality. The quality could be ensured if we reduce subjectivity. The cogency, that is the conclusion, is it is imperative to restructure the Supreme Court. Why? Because we have to segregate functions, the constitutional as well as non-constitutional cases, and deal with them effectively. At the same time, we have to see that we reduce the subjectivity, that is our values. If an individual is judged, his or her values should not be a deciding criterion to decide the final outcome of the judgment. And streamline adjudication, that is, it has to be streamlined, it has to be objective, it has to have a particular framework within which allocation of the cases is to be done, and reduce the dependency on discretionary powers, for example in this case the Chief Justice of India. So in this way, Supreme Court could function effectively and efficiently and reduce the case loads and deal with more case load in the future. This completes the article. Now let us look into another article.